for the invitation to come and speak at this conference. I've spoken at this conference a number of times over the years, and it's always a really interesting program, even for those non-technical people, but those who like to hang around with nerds. It's a fantastic opportunity. So what I'm talking about today is a significant shift in Canada's privacy law that has an impact on privacy breaches. And the timing coincides with an explosion in privacy class actions. And so I'm not sure which is the tail and which is the dog, but they're both kind of marching in tandem. So I'm going to go through all of that and kind of get into some of the weeds and some of I think, the important details, because one of the things that's absolutely clear to me is that the words we use matter, and the words we use matter a lot, particularly when we want to make sure that we're complying with what our obligations are, and particularly if you're talking across kind of different constituencies and different groups. And information security professionals are going to be on the front lines of this. And if our vocabularies aren't aligned, things are going to get potentially a little bit messy. And I saw it most recently, so many people here know about the Nova Scotia Freedom of Information Protection and Privacy website issue. And there's a debate online about whether or not it was a breach. And in fact, I'm going to go through what the new definition is from our federal privacy law. And regardless of what you come to the table with in terms of your expectations or understanding of what a breach is, it fits into the definition of breach in the legislation. And so while you can have the debate about the severity or the cause or all those other sorts of things, but I think having an understanding of at least what the legal background is and what the lawyers are going to be talking about and what the risk managers are going to be freaking out about and what the insurance people are concerned about, making sure that we're all on that same page is pretty important. And so just in terms of a bit of background, so Canada, we have a mosaic of privacy laws. I sometimes call it a mess of privacy laws. It depends who I'm talking to. And so we have public sector privacy laws like FOIPOP. We have health privacy laws like the Personal Health Information Act. We have the federal private sector privacy law, the Personal Information Protection and Electronic Documents Act. We have variability across provinces. Most of those laws are provincial, but the one that we're going to be talking about is the federal one. It's the Personal Information Protection and Electronic Documents Act, and that's the one that's overseen by the Privacy Commissioner. And until relatively recently, there hasn't been a huge amount of excitement with respect to, although obviously kind of privacy lawyers get excited about this, we're easily excited, but when it comes to things that kind of end up in the news or things that end up where kind of people are rushing off to court, there hasn't been much of a move to do that because our legislation is based on an ombudsman model. An individual who thinks they've been aggrieved, they go to the Privacy Commissioner, the Commissioner investigates, and after that process, which will take about a year or two, then the individual can go to court just on their own. There's no mechanism for a class action, and can get damages. And the damages for these privacy breaches have been really, really small, a couple $1,000 perhaps. And so there wasn't any real incentive for people to go rushing off to court. And some provinces have a statutory tort, so you can sue somebody for an unreasonable invasion of privacy, but those have been seldom used until recently. But we reached a turning point in Canada in 2012 with a case called Jones and Tsige. And this was a case where I had two employees of the Bank of Montreal. Miss Jones was the plaintiff, Miss Tsige was the defendant. Miss Tsige's ex-husband was dating Miss Jones, and Miss Tsige was not happy with the child support or the support payment she was receiving, and so went and looked into her colleagues' banking records to find out whether she was getting money that Miss Tsige thought was intended for her, should have been for her. And she looked into that bank account dozens and dozens and dozens of times and was finally caught by the Bank of Montreal and was disciplined, and Miss Jones sued her and was unsuccessful at the lower courts, but the Ontario Court of Appeal completely radically changed privacy law in Canada, at least on the civil side, and awarded her damages and said general damages, so just for the feeling of being intruded upon, the range of damages is from nominal to $20,000, and gave Miss Jones $10,000. Now her legal fees were $120,000, but anyways, it was a little bit more than just a notional, here's a couple $100. And so that decision imported into Canada all of the US privacy torts that exist, where previously they were not there at all in Canada. And so in the Tsige case, in the Jones and Tsige case, the cause of action, so the legal claim is something called intrusion upon seclusion. And so and the Canadian courts modified it a little bit to include recklessness, so not just intentionality. So anybody who intentionally intrudes upon the solitude or seclusion of another or his private affairs or concerns is subject to liability to the other for the invasion of his privacy if the intrusion would be highly offensive to a reasonable person. And you have to understand the judge is going to be that reasonable person. And damages are presumed. If your seclusion is intruded upon, you are automatically entitled to damages of some measure. It has to be intentional, but it can be reckless, and that gives plaintiffs the ability to get into the pockets of the businesses who might have been reckless in securing information or not supervising an employee. Now, as I said, it's generally not viable for individual claims. Now, Ms. Jones ended up having to go to the Court of Appeal, and so that explains why her legal fees were so high, but frankly, going to court ain't cheap. But it completely opened the doors for class actions. And since then, we have had an explosion of privacy class actions in Canada. There's a second of the privacy torts that was imported into Canada in Jones and Tsige, which is publicity given to private life. So one who gives publicity to a matter concerning the private life of another is subject to liability for the invasion of privacy if the matter publicized, or even just the act of publication, is of a kind that is highly offensive to a reasonable person and is not of legitimate concern to the public. So they have that little last bit there to be a little bit of a safeguard for legitimate news reporting. But if it's not legitimate news reporting, somebody who publicizes information, private information about another, is going to be liable for that publicity. And we also have other causes of actions, other legal claims that have come into the privacy arena in ways that they hadn't before. So breach of confidence, this had usually been used for violation of non-disclosure agreements, but it's being pled in these privacy class actions. And one nice thing about it from the plaintiff's point of view is it's something called an equitable claim, which gives the court a lot of latitude to kind of do justice to the parties and try to make things right, which is not necessarily the case with other forms of legal claims. And then usual negligence is also pled when it comes to lost hard drives and things like that. The one was careless in that. One of the things that distinguishes negligence from some of the other ones is that you have to prove harm. And it's a challenge, and the courts are starting to grapple with this notion of what is a privacy harm. Certainly with the Ontario Court of Appeal decision in Jones and Tsige, just being creeped out, have your solitude intruded upon is enough that they would say that is in fact a harm. But there's also debates about, so for example, if your payment card information is compromised and your bank is going to make you whole and is just the thought that somebody might do something wrong, is that in fact a harm? And the courts tend not to recognize that. It has to be something a little bit more solid. But the courts are getting much more nuanced about understanding the nature of privacy and privacy claims, which is to the benefit of plaintiffs and perhaps problematic for other defendants. So we've seen many class actions, privacy class actions, come about in Canada since that 2012 decision. None of them have gone to trial yet, but it's quite rare for a class action to go to trial. They generally settle at some point. And we've had even ones in Nova Scotia. We had a case where an individual employee of the Southwest Health Authority browsed through inappropriately medical records of 750 people. The health authority discovered that using normal sort of auditing tools and disciplined the individual. A class action was formed and it was settled for $1 million. So each of the people whose information was looked at got $1,000 and the lawyer got $250,000 or something else like that. So there are incentives built into that system for these claims to get made, and also sometimes for these claims to be settled in order to make them go away. And when you look at the information holdings of organizations, often you're dealing with vast amounts of information about a vast number of people. And you multiply even $500 a head, you multiply that across 60,000 customers or 100,000 customers or 1 million customers. And you're talking about kind of company killer potential claims. And so there's an importance to make sure that you're adequately insured for these things. So with that in the background, so the galloping class action lawyers heading off to court suing at the drop of a hat, we have new coming in Canada as of November 1, data breach notification requirements. And Canada is actually behind the curve on this. Right now, there are 49 US states that have data breach reporting requirements. North Dakota is going to catch up and make it 50. We have in Canada In the private sector, only one law, the Alberta Personal Information Protection Act, requires notification to the Privacy Commissioner, or reporting to the Privacy Commissioner, and potentially notification to the individuals if there's a data breach. But PIPEDA, our federal privacy law, was amended by something called the Digital Privacy Act a number of years ago. And the one specifically dealing with data breaches come into effect on November 1 of this year. So we just had the final regulations posted in the Canada Gazette a couple weeks ago, and so this is something that we have to look forward to. Now, while we've been waiting for some of the details to emerge in the regulations in terms of what has to be in a report to the commissioner and what has to be in a report to the individual, many organizations have in fact been following these rules, generally speaking, with respect to data breaches that are of any significance. So that's reporting to the individuals and reporting to the Privacy Commissioner. Because one thing that we found is that if an organization doesn't do that, and it's a material breach of any way, it actually has a significantly negative impact on the reputation of the organization, suggesting that there's been some sort of a cover-up. And actually what prompted all of this was that California, for a while, was the only state in the US that had data breach reporting requirements. And you might remember something called the Choice Point breach that took place a number of years ago. Choice Point is an information broker. They do background checks and credit reporting and public record searches and things like that. They had a massive database. Now, unfortunately, they didn't use that database in order to do background checks on their customers. And some scammers signed up to get access to the database and started downloading massive quantities of background check information, including credit reports and things like that. The company discovered that, I think because of a whistleblower, and gave notice, as required under California law, only to people who lived in California. And questions arose from people in Texas, for example, said, hey, were we affected? And they lied and said, no, it was only people from California. Then, of course, the information comes out. And pretty quickly, US states started passing data breach notification laws. And these have been in place for quite some time. And I also flagged US laws, not only just in terms of the trend and the fact that we're behind the curve, but catching up on this, is that when you have a data breach, you need to be worried about what laws might, in fact, be implicated. So an example that I sometimes give, so my father-in-law was a professor at McGill. He retired. After he retired, he met a woman who lived in California, and he married her, and he moved to California for his retirement. He still had bank accounts in Canada, but he became a resident of the state of California. And California data breach notification requirements depend upon the residency of the individual. So if his TD bank account had been compromised, or TD had a data breach that involved his information, TD would have had a legal obligation under California law to notify my father-in-law, but wouldn't have had any obligation to notify anybody who lived in Canada. And it would, in fact, be an offense under California law, and I'm willing to bet TD has some assets in the United States that might be kind of subject to. So one needs to be mindful of that. And one of the nice things that we're going to have in Canada is we're going to have a relatively consistent notification regime, but it's not consistent in the US. So in some instances, you have to give notice to the Attorney General. In many cases, you don't. In some cases, you have to give notice in writing. Email is not sufficient. And so, in fact, becomes an incentive to collect more information about your customers in terms of where they live and what their physical address is, because there's sometimes not a whole lot of flexibility with that. And there may also be a common law duty to notify somebody. So usually, if you cause harm to somebody or potential harm to somebody, and giving them warning of that would allow them to take steps to mitigate that harm, well, then you probably have a legal obligation to do that. So this simply says that kind of everything is pushing towards notification. And just about every privacy class action that I'm aware of in Canada that's currently working its way through was prompted because of notification. So on one hand, it's a really good thing to notify, and soon will be a legal obligation. On the other hand, it's disastrous because as soon as a paralegal in a class action law firm gets that notice of information compromise, you're going to have a potential class action lawsuit on your hand. And you might have multiple class actions because class actions are generally provincial. And so you might have a claim filed in Nova Scotia, another New Brunswick. There's a lawyer in Newfoundland who when I went to check on the status of one of the class actions that he was pursuing against one of the health authorities in Newfoundland, there had been so many breaches that in fact he had a drop-down menu, click on class actions and health authorities. Northern Health, Western Health, Eastern Health, Southern Health, and kind of multiple kind of class actions that is just kind of coming out of these sorts of factories. And so one needs to be aware of what is likely to happen after you give notice. And of course, probably the ultimate theme is try to avoid a breach happening in the first place. So I'm going to tell you about the data breach notification requirements in the legislation, and there's a Easter egg, a smelly, horrible Easter egg buried in the legislation that hasn't gotten a lot of attention that information security professionals need to know about. So these amendments were passed under the last government, created the breach notification regime, and as I said, it's going to come into effect on the 1st of November of this year. One thing to notice, so many people characterize our privacy regime as maybe somewhat weak because our privacy commissioner can't hit you with massive fines like European data protection authorities, can't send people to jail. But there are some places in the legislation where it creates offenses. And of the few offenses are going to be introduced or expanded with this amendment, because if you don't provide notice to the commissioner or to individuals when you legally have to, that's an offense. It's a federal offense. If you don't keep the records that are required to be kept under this legislation, under the amendments, that is also an offense. And so that should probably get people's attention. So I mentioned at the beginning, we need to have a common vocabulary. And one of the things that kind of drives me batty sometimes is this happened in CASL, Canada's anti-spam legislation, where they take words that we've been using all the time with a common understanding of the meaning, and they give them a new meaning, or they give them a new definition. And particularly when you have two laws, you have our privacy law and our anti-spam law, that implied consent mean two completely different things in these two statutes that stand side by side. It drives me nuts. And so you need to be aware of what is the definition of a breach under the legislation, because it might not line up with what your expectations are. And there's some unfortunate things in here. So a breach of security safeguards means the loss of unauthorized access to or unauthorized disclosure of personal information resulting from a breach of an organization's security safeguards that are referred to in Clause 4.7 of Schedule 1, or, and this is important, or from a failure to establish those. So if you have safeguards and they're breached and they result in unauthorized access or unauthorized disclosure or loss, that's a breach. If you didn't have safeguards in place and you end up with an unauthorized access, that is also a breach. So you need to think of those two different things. And there's a quirk in here that I think is problematic and is actually kind of bad public policy. So the Digital Privacy Act adds section 10.1 to PIPEDA that says an organization has to report to the commissioner, so the privacy commissioner, any breach of security safeguards involving personal information under its control. And then here's the test. If it's reasonable in the circumstances to believe that the breach creates a real risk of significant harm to an individual. Not all the individuals involved, but to an individual. And then there's requirements in the legislation and in the regulations that are looking at what you have to tell the commissioner. And then we have subsection 3 that talks about notification to the individual. So unless otherwise prohibited by law, and I don't know of any other any prohibitions that would prevent this, an organization shall notify an individual of a breach of the organization's security safeguards involving that person's personal information, again, if it's reasonable in the circumstances to believe that the breach creates a real risk of significant harm to the individual. So you have to notify that individual. So the test is the same, which is different from in Alberta. In Alberta, you have to notify the commissioner on a relatively lower, somewhat lower threshold. And the commissioner will tell you whether you have to notify the individuals. And I know the Alberta commissioner quite well, and she said in every single circumstance, people just notify the individuals and the commissioner at the same time, and they call it a day. She's actually never had to tell somebody to notify the individuals. And so here's what the baseline is. So Principle 4.7 in PIPEDA sets out the obligations for an organization to safeguard personal information. And it's technology agnostic. I think it's a good workable definition because it allows privacy and security pros to actually do their jobs. It's not, so the legislation was drafted in 1996, but I think it's relatively resilient. It says you have to protect personal information using security safeguards that are appropriate to the sensitivity of the information. I'll talk a little bit about what that means. And it talks about some of the hazards that it has to be protected against: loss or theft, unauthorized access, unauthorized disclosure, copying, use, or modification. And it says kind of information has to be protected regardless of the media, regardless of the format. So paper, electronic, doesn't matter. You need to safeguard it, and you need to use safeguards that are appropriate to the sensitivity of that information. And so the legislation doesn't give you the easiest tool to determine exactly what is sensitive. But we're talking continuum. And one of the things that I like about PIPEDA is that things are principles based, and there's there's a flexibility to it. You can use some good judgment. It gives some examples, like medical information is generally seen as being sensitive. It gives this kind of illustration that the names and addresses of subscribers to some special interest, i.e. porn magazines, might be considered sensitive compared to a subscription to Maclean's magazine or Hot Rod magazine or something else like that. So you can have the exact same information, but it can be very different sensitivity depending upon the context. So for example, your name on a list of people who went to a hockey game, probably not sensitive. But your list on the roster of patients for a psychiatrist, that is sensitive. The exact same information, your name, very different context. And I think we need to think in terms of risk management concepts and possible harm. And we're given some tools. I'm going to talk about kind of what a real risk of significant harm talks about. And to understand sensitivity, I think it's useful to look at the significant harm portion, because the law is pretty broad in talking about what sorts of harms we're protecting individuals against. But we think of what is reasonable and what is appropriate to safeguard, measures to safeguard information dependent upon the sensitivity. And I tend to think about, and I'm not an information security professional, I rely on IT pros and IT security pros in order to kind of give advice to the client on what is appropriate in the circumstances and what is the standard. And I often do think of kind of what is the standard? What is the standard of care? In negligence, in order to have a claim in negligence, there has to be a standard of care and a duty of care to the individual who's about to sue you. And if you fall below that standard of care and it causes harm, that's what completes negligence. And so what is the standard of care? What is the general prevailing practice in your industry or in your sector? What is used to protect this information? And I say, then at least do that and go one better. Like, add additional safeguards and measures, because it's one of those, I forget what exactly the saying is, you don't have to outrun the bear, you just have to outrun the other person. And so it's that sort of, so you want to be able to say you are better than the standard in your industry. And one thing that's nice actually is the Privacy Commissioner actually has shown some common sense in interpreting this and has recognized that you could spend $1 million to protect $1,000 worth of information and nothing is foolproof. And so I think in connection with an investigation related to a 0-day, the company had done everything that they could in the circumstances to protect information. They still had a compromise, they still had a breach, and the commissioner said you did everything you could. You lived up to the obligations of the legislation, stuff happens. And so that's at least a nice measure of common sense. I'm not sure the class action lawyers would take the same point of view, but at least when dealing with the commissioner, that's the case. And also imagine that if you're the CISO of an organization, there will come a time when you are in the cross-examination chair and some lawyer is asking you about your decision-making and questioning your decision-making about how information was protected and what you chose to do, but also importantly, what you chose not to do. And so imagine yourself now sitting in that chair in 5 years, and hopefully that will inform the decision-making that's going on. So let's look at, kind of break down a little bit more of this test. So real risk of significant harm. And real risk in the legislation tells us it depends on the sensitivity of the personal information involved in the breach and the probability that the personal information has been, is being, or will be misused. And there can also be other prescribed factors, but they didn't add any more in the regulations. And so here's two examples that kind of are good illustrations of the real risk part of it. So in the circumstances, what's the likelihood of mischief taking place? So Condon v. Canada was a situation where an individual employee of the Department of Human Resources and Skills Development Canada, with the best of intentions, saw that a database of Canada student loan recipients wasn't being regularly backed up. And so in order to safeguard that information, I guess ran to Staples and got an external hard drive and backed up that information and put it in a cabinet, in a locked cabinet. And then a number of months later, he went looking for that hard drive and it was gone. That hard drive contained information, financial information of 600,000 Canadians. And it just disappeared. They have no idea where it went. It's probably at the bottom of a landfill in Gatineau, Quebec, or somebody took it, wiped it, and it's full of movies, or something else like that. Who knows? But there was no indication. So it was in a locked cabinet, in a locked office, in a secure part of a locked government building. No indication of break-in or anything else like that. And all 600,000 people, their credit records have been examined, and none of them have a higher than normal incidence of identity theft. So it's likely that no mischief has happened with that hard drive. From the circumstance, think, okay, well, there's an open question. We just don't know. But carelessness, and maybe it just disappeared, or maybe aliens or something, is maybe part of the explanation. Compare that to the Ashley Madison situation, where you had people who were determined to get access to that information, who've been crawling through their systems for months, and were determined to use it for blackmail. So you can assume in those circumstances, bad things are more likely to happen. And so that's how you evaluate kind of what's the real risk. Is it somebody who lost an encrypted laptop, or is it somebody whose information was stolen, and you can assume some sort of malevolent intent? And so it is kind of, it's predictive, but you use your skills and hopefully your spider sense and figure out, okay, well, what is going on here? Are we dealing with bad guys, or what's the likelihood that bad things are going to happen? So the second part of it is the significant harm, and this helps also inform the sensitivity piece. So significant harm, this is from the statute, includes bodily harm, and just note how broad these kind of harms are imagined. So privacy is sometimes thought of being, like when you think privacy breaches, they think kind of payment card fraud and identity theft and stuff like that. There's much more going on here. So even understanding kind of conceptually what privacy is meant in the legislation might require readjusting some of your, recalibrating some of your thinking about this sort of stuff. So bodily harm, humiliation, damage to reputation or relationships, loss of employment, business, or professional opportunities, financial loss, identity thefts, negative effects on the credit record, or damage to or loss of property. So a pretty broad understanding of what a privacy harm could be. And note it only talks about these as being significant compared to other ones that are trivial. So you do a little bit of a risk analysis, kind of what's the real risk? Is there a risk that bad things are going to happen? And what would those bad things look like in terms of determining those, where you are on the continuum? And so we now have information about what has to be in one of these reports to the commissioner. And so you have to tell the commissioner what you know about the breach, the circumstances of the breach. If you know the cause, you need to let and you need to do this kind of forthwith, without delay. In the new European General Data Protection Regulation that's going into effect a month from today, you have 72 hours to notify, which is dramatic, which is, I'm going to talk a little bit about some of my experience in this. It's very, very seldom within 72 hours that you have enough information in order to pull together a comprehensive report. And frankly, you probably want to be looking into the breach rather than filling out paperwork during that time. But okay, so you have to let the commissioner know what happened, what was the cause, if you know at that time, a description of the personal information involved in the breach, an estimate of the number of individuals for whom the breach creates a real risk of significant harm. You have to describe the steps you've taken in order to reduce the risk of harm to each affected individual. So you have to have already started the process of trying to do things to mitigate harm to those individuals. What steps have you taken to notify the individuals, which is also your obligation. If you have to notify the commissioner, you have to notify the individuals. And you have to provide them with contact information, which is a bit of a no-brainer. So it's not an enormous report, and already on the Privacy Commissioner's website, they have a form, they have a PDF that you can download, fill out, and email back to them, or you can fax it to them, or whatever's the avenue. You have to provide the information to the Commissioner securely, and I'm not sure how they determine that, but because they do take these reports by email. So I guess they assume that to be sufficiently secure. The report to the individual, the Act says the notification has to include sufficient information to allow the individual to understand the significance to them of the breach and to take steps, if any are possible, to reduce the harm that could occur. So to watch their credit report, or hey, we're setting up credit monitoring, or those sorts of things. It should also contain any other prescribed information, and then we have the prescribed information that came out in the regs. So this is in Section 3. You have to tell them about the circumstances of the breach, some of the things that are quite duplicative of the information you're giving to the commissioner. And You have to have a toll-free number or an email address so that they can ask questions, which makes sense. And then finally, you have to let them know how they can complain to the organization and the fact that they can complain to the privacy commissioner. So you're almost inviting them to do that. One thing that would be very important, I've been involved in many times giving notices to individuals and giving notices to commissioners. The tone of the letter, of the communication, really, really, really matters. It is the first contact that an organization is having with an individual conveying bad news. And I've seen that it can, in fact, improve a relationship with a customer. And I've seen that it can destroy a relationship with a customer. I remember a number of years ago, there was a data breach involving Chrysler Credit, and one of my partners, a tax partner, came kind of galloping into my office and put a piece of paper on my desk that he was a lifelong Chrysler customer and he got notice of a privacy breach involving his information. And I read the letter, and it was clearly written by a boardroom full of lawyers. It was so much CYA, cover your butt, that it was not at all informative, and it was really kind of, oh, woe is us, Chrysler Credit, rather than any sort of empathetic outreach to somebody who's just receiving bad news. And so they lost a lifelong customer. And I don't know, in my partner, and I don't know how many others had that experience, but I've had other cases where the individual really appreciates getting the notice and appreciates kind of the care that went into it. I'm not kind of bad-mouthing lawyers generally, but it's important that these are well put together and can kind of convey understanding and empathy, but don't necessarily accept the blame, but it's not all kind of covering your behind as well. But so kind of care really matters for these sorts of things. Now here's the cruddy Easter egg that's in the legislation. And I understand why it's here, and I understand the rationale for it, but it's going to require organizations to create a time bomb within their own companies. So every organization has to, in accordance with prescribed requirements in the regulations, keep and maintain a record of every breach of security safeguards involving personal information under its control. Not just those that create a real risk of significant harm or a minor risk of moderate harm. Every breach of security safeguards you have to keep a record of it. And those records have to be kept for 2 years. And you have to provide those to the commissioner when the commissioner requests. If you don't keep those records, it's an offense. If you don't provide it to the commissioner, it's an offense. And also, this stack, this document, this log, is going to be the first thing that class action lawyers ask for, because they will want to prove that you have a track record of crappy things happening and being careless and reckless with your information. And the way they can prove that is 500 minor breaches without necessarily evidence of taking steps to improve upon it. And I'm going to talk a little bit about legal privilege as well, which is an important thing. But every organization is going to have to do this. And this is going to create a problem within organizations. So recall the definition of a breach. So it's unauthorized access to or unauthorized disclosure of personal information resulting from a breach of safeguards or from not having those safeguards. It's not from not meeting the standard. It's unauthorized because it didn't meet the standards set out in section 4.7. So if you have safeguards in place that are higher than required, than the bare minimum under the law, so let's say that kind of here's the bare minimum and here's the standard you adopt, it's great, and something compromises within that additional layer. That's a breach of security safeguards, and you have to keep a record of it, and so you're kind of feeding a litigation trail later down the road. So here's the scenario. An organization adopts a clean desk policy. It might not be legally required. There are other steps you could take to have a clean desk policy, but you have a clean desk policy, and it's in order to safeguard information, including personal information. Somebody leaves a piece of paper out on their desk, kind of face up, and the cleaning staff comes into that office that evening. That is a breach of security safeguards. That might even be an employee of the organization, not even an outside contractor, who's subject to confidentiality obligations. But if they saw that information, that was, in fact, the result of a violation of a clean desk policy, and you have to keep a record of that. Now, just imagine within an organization how difficult it's going to be to get people to document these sorts of trivial things that happen on a daily basis. Because certainly that employee is going to go in that morning and notice that piece of paper, and they're just going to put it away and assume no harm, no foul. But the act of doing that is an offense. That has to be documented, thoroughly documented, according to the prescribed requirements, and that record has to be maintained for the Privacy Commissioner and for any class action lawyers. Include, for example, you hand your unlocked smartphone to your kid to play Candy Crush or something in the backseat of the car, and they flip through and they see your email notifications. That's an unauthorized disclosure of personal information that would have to be documented. So hopefully they're not going to get that stupid about it, but this is kind of the implication of it if you draw a straight line from what the requirements are to the conclusion. And so preparing for the inevitable. So the best thing that can be done, obviously, is to have really good information security practices that make it difficult for these sorts of breaches to happen. And I know that I'm probably preaching to the converted in a number of ways with respect to preparing for these sorts of things. In my experience, one of the things that you really want to have is and it depends on the size of the organization. Larger organizations are probably going to be more likely to have written policies and things like that. But small ones need to have an understanding of what they need to do as well. And it's the small and medium ones that are probably the least secure and have the least resources to devote to this. And when they discover a data breach, people are going to be running around with their pants on fire. That it's going to be kind of battle stations, it's going to be panic, and it's going to be a whole lot of confusion about who is responsible for what. And in the process, they're probably creating additional liability by doing that. So having a plan that you know, that you have access to, that you've rehearsed, is very, very helpful. And it's a multidisciplinary practice. And soon, now that all these minor breaches have to be reported, somebody's going to have to triage those. Somebody's going to have to review them. And you're probably going to want to action many of those, just so that you can say, oh yes, this minor thing happened, and we looked into it, and we took additional steps to make sure this sort of thing doesn't happen again. And I'll tell you a little bit about what I think is kind of the rationale for this requirement. So people might recall a number of years ago where there was it ended up on the front page of the Globe and Mail and the Toronto Star, where CIBC had a breach, you can call it a breach, under the legislation it would be a breach, where a whole bunch of documents, CIBC documents, were being faxed to a junkyard in West Virginia. And what happened was that CIBC, and this is during RSP season, and so February in whatever year it was, kind of, they're running off their feet, and so they had a system. They set up a central office that would manage all of the RSP sort of stuff. And so at all the branches, they would fill out the forms, include the name, customer account number, address, probably social insurance number, stuff like that, because it's a registered product under the Income Tax Act. And those documents were to be faxed to the head office. And so they set up a toll-free number to do that, and it was like a 1-866 number. And human error meant that so many people at so many different branches dialed 1-800 and then the other 7 digits. And that 1-800 number went to a fax machine in a junkyard in West Virginia. And so the guy started receiving these faxes and would call, so it would say, if you receive this fax in error, please call this number, which was the local branch. And he would call, and the person would say, oh my goodness, I'm sorry about that. Can you kind of destroy the document? And we'll be more careful next time. Well, CIBC has hundreds of branches. And so this guy was getting faxes from like Burnaby, British Columbia, from Calgary, from Edmonton, from Halifax, from all over. And he stopped calling them back. And in fact, the only time it came to the attention of CIBC's head office was when the guy sued the bank for screwing up his fax machine and the amount of paper that he was having to pay for. And so you had all these breaches that were happening all across the organization, and they were all the same breach, and they were all involving sensitive information, but there was no requirement to collate that information and analyze it and understand it. Because certainly, once that happened 5 times, you kind of notice a pattern, but you had to have somebody who would notice that pattern. And so this is one of the things that's going to be required in order to do this. And because of this self-reporting requirement, you're going to have to develop within your organization the means by which people are empowered to report these things without fear of repercussions. Because frankly, many of these are going to be caused by individual screw-ups, and you don't want people afraid to report it because these things are going to have to be reported. Obviously, kind of when the breach is discovered, you want to contain it, you want to notify the right people within the organization. In my experience, it's a multidisciplinary group of people, and you want to contact legal counsel. And I'm not saying that simply to be self-serving. You want to think about, obviously, you want to contain it as much as possible. You want to minimize any further harm if it involves kind of unplugging that rack of servers or taking down the firewall or whatever it is, whatever's reasonable in the circumstances, but there has to be a decision maker there who knows what's reasonable. Is it a criminal incident? Should the police be notified? In my experience, the police aren't very helpful, although increasingly they have a SWAT team for raiding houses on these sorts of things. But so I would probably consider whether or not the police should be notified, but it's been my experience generally that they say this is a civil matter or we don't have the resources. You bring in really good forensic folks who have law enforcement experience and background who are able to produce a report that will have actual legal value if you can then hand that over to kind of with a ribbon around it for help. You have to do the assessment. All the information that you're going to need in order to fill out the report is information that needs to be collated. And I'm running out of time, and so I'm going to skip through some of this. But one thing that's important to note is that at least it's been consistently my experience, and it may be yours as well, that the magnitude of the breach is almost always not as bad as it first appears. That you have that moment of kind of panic, catastrophizing, I'm not sure what it is, I think it's a relatively normal human thing. The longer you look at it and the deeper you look into it, you realize in fact that it's not as bad as you initially thought, or the scope, the number of people involved is actually much smaller. I was dealing with a client, noticed that there was a glitch on their software as a service. Imagine that it affected all of their customers, and so we're about ready to do this kind of significant notification to tens of thousands of people, and then realize as they dug into it, it related to a code glitch that was related to a particular update of the software that was only live for 6 hours. And so initially they saw the error, assumed it applied across the board, but digging into it showed it probably only affected a handful of people. Notification, obviously the commissioner is one of those requirements, and but I want to talk about privilege in the 3 minutes I have left. So there are two kinds of privilege. So there's legal advice privilege and there's litigation privilege. Legal advice privilege is where the communication is intended for obtaining legal advice. And so just because you're talking to a lawyer doesn't mean you're obtaining legal advice. So that doesn't even necessarily become privilege. And there's this thing called litigation privilege, which creates a temporary cone of confidentiality where you're collecting information for the purposes of actual anticipated or actual litigation. So you are being sued or you know you're about to be sued, and the information you collect in order to prepare for that is going to be privileged. I often see forensic examiners' reports and things like that are marked as being privileged, where I didn't receive instructions on getting that report prepared. There was no lawyer involved, and so those words are just empty and are ultimately meaningless. But you want to have legal counsel involved from the very beginning to protect as much as you can. Those reports that you have to give to the commissioner, those aren't going to be privileged, but to protect as best you can your legal or what happened. We're involved in a class action lawsuit against the government of Canada related to Health Canada compromising the privacy of 43,000 individuals who are licensees under the Medical Marijuana Access Program. And one of the first things we discovered is when we did our access to information request to get more information about what was happening in that office is a consultant's report. They brought in a privacy consultant who essentially said, this place is a dumpster fire. This place is so badly run and badly managed, your privacy, you have no hope of getting down to a level of 0 privacy breaches. You need to hope to get down to a reasonable level of privacy breaches. And because it was prepared by a consultant and not a lawyer, it's discoverable. And the case probably isn't actually going to go to trial. It will probably settle, but I would really enjoy cross-examining the person responsible on the basis that your place was a disaster. And that could have been prepared by a lawyer who could have given the same privacy law compliance advice, and it would never have seen the light of day. And so think about that. Think about the fact that some of these things, if they dig in adequately, they're going to find, you lift up enough rocks and you're going to find some worms. And so just be mindful of that. You don't want to be necessarily creating exhibits that will be used against you.